So the first session is about trying to understand the very idea of judicial independence.
Hello.
And we have two panelists here. So
Hello.
we're trying to get Professor Kim Lynn Chappell. She's going to speak. Kim, we are just trying to work it out. Can you hear us?
I can hear you now.
Very good, wonderful. So I think we have a trick, it seems. That's how it works. And now Adrian told us the trick. Okay, so without any further, I know it's very odd time in the US. So let me start immediately without any further ado with Professor Kim Chappell. And she's going to talk about who judges should be independent from. Kim, you have the floor.
Can you see the cover slide? So what I'll just do is I'll just hit next slide. And my idea is to go through slides very quickly, and I'm happy to pass on the slides to anyone who would like more chance to look at them. Yeah? Can you hear me okay?
Yes, I think we can hear you.
Okay, great. So let's go to the first slide that says today's talk, which I think you might have there. Yes.
Yeah.
So my talk today is on what should judges be independent from. And what I plan to cover is some ideas about what judicial independence might mean and how judicial independence is ensured. And of course, in the course of that, we also have to ask what judges are dependent on. And the answer is going to be the law, but this is not going to be a very straightforward question. So to the next slide. What is judicial independence? Yeah, I think I can see that. There you go. Okay, good. I can see a little bit of the slide behind you, so that way I know you're on the right slide. So I'm going to quickly discuss 4 theories of what judicial independence could mean. Independence from the parties to the case, independence from partisan politics, independence from other political institutions, and independence from political thinking. And again, judges are not perfectly free agents, so they have to be dependent on something, namely the law. So next slide. The first theory is judicial independence as impartiality. And this conception of judicial independence refers primarily to independence from the parties in the case, right? So this is a criterion for the independence of a particular judge, that they're not dependent on the parties before them, but they base their decisions on law and fact. Next slide. The slides go really fast. That's the only way. And again, feel free to ask me for them afterwards. So the question is, how is this usually ensured? And usually this is ensured at the level of the individual judge through recusal rules. So, but there are several dangers. If a judge that is partial does not recuse, then this is a dilemma, because the judge will then be biased in favor of one of the parties, or therefore dependent. But there's also a problem of judges recusing when they shouldn't. For example, when they've been bullied, or when the judiciary is under some kind of political threat, and judges remove themselves from cases so as not to be subject to a certain kind of political pressure. So next slide. So the question then is how to design recusal rules. This picture, by the way, is a picture of Viktor Orban as judge and jury. Actually, it shows him as all the judges on the Constitutional Court of Hungary, which is a court that he was responsible for packing. So the question is how recusal rules should be designed. And this is where you have a huge range of practice internationally. Probably the worst practice is at the US Supreme Court, where each judge decides for themselves whether they're sufficiently conflicted to get out of a case. And I think a best practice would be something like the German Federal Constitutional Court, where judges' colleagues actually make the determination of whether a challenged judge should sit on the case. But this doesn't yet address the question of how to protect judges from reprisals if they rule against powerful people. So here's where we go to our next theory of judicial independence in the next slide, which is to think of judicial independence not just as independence from the parties, but to think of the judiciary as a whole as being more buffered from political pressure. And here the primary danger, or the primary worry, is that judges be independent from electoral and party politics, so that the judiciary is an institution free of direct partisan influence. Next slide. So where are the dangers in this system? Well, the dangers are very often in the system of how judges are appointed in the first place to the bench. This is where every judiciary is very vulnerable, because the question is, how do judges get to the bench in the first place so that they can be independent? And the selection process makes a huge amount of difference. Obviously, in a lot of places, the process of judicial selection is a professional process guided by judges or experts. I think the Indian Supreme Court may be unusual in the world in having only the sitting judges make a decision about who the future judges will be, although I gather this is now actually an issue. I'd love to hear more about this. In most other systems, there's some combination of political practice and professional judges, and in some cases, the process is completely political. So the concern, it has to do with these political processes where judges are either appointed by politicians or elected directly. In fact, one thing probably most of you have been hearing, that the U.S. has an election coming up next Tuesday, and in a great number of states, all the judges are up for election. The U.S. is one of the few places on earth that does things like that. So both these political processes and the elected processes raise questions about judicial independence. So next slide. So how is independence of the judiciary shored up under these circumstances? So usually by trying to include experts in the mix of judicial selection, or if the process is political, by requiring supermajorities or multiple decision points, so as to try to prevent what really is the worst case, which is the executive directly appointing judges alone. And of course, one of the other ways that judicial independence can be ensured in this way is through paying attention to the length of terms, either by having fixed terms of appointment, so that when judges are elected isn't up to the political branches, but is something that occurs on a regular basis and is staggered so that no government can get a majority on any particular court. But also life tenure makes that a lot less subject to political influence. Okay, next slide. So the third theory of judicial independence is what I call judicial independence as legitimacy. And this is where the judiciary gains its independence through its position in the system of separation of powers or checked powers, so that the judiciary has a role to play that the political branches are not supposed to intervene in. And the courts possess the power to decide legal questions free from the influence of other branches, so that it immediately becomes illegitimate for the other branches to intervene. Next slide. So here the problem is that the judiciary needs institutional protection as well as individual protection. The judiciary needs protection from things like jurisdiction stripping, changes in the legal structure or function of courts, and individual judges need protection from being removed. So one question is how the judiciary retains its integrity in a system of separation of powers. Who controls the jurisdiction of the court and who controls the tenure of judges? Next slide. So here the problem then has to do with, who gets to take judges off the court, who gets to decide what jurisdiction the courts have. And this little cartoon here is a sort of unfortunately current one. This little cartoon showing the current president of Poland, who fired the president of the Polish Supreme Court in July. And this shows the bloody sword and the bloody head of the judge over his head. They did this by lowering the judicial retirement age, which is all the rage in Eastern Europe these days. The Hungarians did it first. So this is the problem, is how do you get rid of judges? And here is where you need some system for removing judges that isn't just a purely political process. And usually the way this is buffered against is through having some either impeachment process that has multiple institutions that are involved, or disciplinary procedures who are run by the judges themselves. And then the question is, who appoints the judges who carry out this discipline? I might add that in Poland, where the government there is in the process of trying to gain control over the Supreme Court, they've just created a special chamber of the Supreme Court where all the judges on that have been appointed directly by the president, and that's the chamber that's going to engage in judicial disciplining individual judges. So we worry a lot about the independence of the judiciary in Poland. Okay, next slide. And so here is where I've sort of covered a lot of this slide. The main way of trying to maintain judicial integrity here is to have a process that essentially has multiple checkpoints and a lot of process before judges can be removed. Okay, next slide. The final theory of judicial independence I want to talk about is judicial independence as what I call legality, which has to do with the independence of the judiciary from purely political ideology. This is where we should think about a separation of the legal from the political achieved through a distinctive method of reasoning and interpretation by judges. So the reasoning matters and not just the result. The next slide, please. And here is where there's a vulnerability to legalism, to using uniquely legal reasoning. And that is that the public doesn't typically understand it. It's technical and hard to understand, even for the politicians. So the question is, how to make the decisions not appear to be so political, how to maintain the trust of the public in the basic neutrality of the judiciary. So the next slide. And so here is where it seems to me that this is one of the places where judges really need to pay attention to gaining broad public support for their opinions, not just in a public opinion sense, but in a sense that the values underlying the decisions should be made clear and should be applied in a transparent and predictable way. And in this case, public education on the importance of the education of the independence of the judiciary really matters. Okay. Next slide. So as you can see, there are a lot of different things judicial independence can mean, but of course judges are not just free agents able to do what they want. So the question is, what really constrains judges? And of course, the obvious answer is the law. The problem is that the law itself comes from a political process. So next slide. So here's the problem. Can the political process that produces law also compromise the independence of judges, and what can judges do about it? So let me just give you one example. In 2015, you have the telephone. Yeah, okay, actually you're one slide ahead, that's fine. So one of the problems, I see that Sergei there is recognizing the Soviet telephone. And so, yes, so telephone justice. So one of the problems is that the standard way we think of the compromise of judicial independence, right, is that the judge is called by the justice minister or someone and says, decide this particular way in a particular case, okay? But the problem is that politically, and this is actually what happened in the Soviet Union more prominently, you can get the same result by designing the law carefully. Right? So the judges really have no choice about how they design cases. Okay, so this is where you can go to the next slide, the two forms of judicial dependence slide. And so we can think of judicial dependence on the law as happening at the level of the case, right, where the judge is given direct political instruction on what to do in the specific case. The case is handled as an exception, the direction is secret, there's no separation of powers, the order goes from the political official straight to the judge. Or you can think about dependence at the level of the rule, where you have a statute created through a political process. The statute creates a rule of operation for the courts. The rule is public, and it was obviously enacted using separation of powers, so the legislature enacts a law, the judiciary applies it. But what if there is really only one answer? So, for example, in 2015, as this migration crisis hit Europe, the Hungarian parliament passed a law that said that any person who entered Hungary through a safe state could not get asylum. Can you hear me? I'm getting a poor network connection.
No, we can definitely hear you.
Can you hear? Okay.
Yes.
Good. Okay. I just got a poor network signal connection on my phone here.
That may be the signal that may be the signal that you need to wind up.
Can you hear?
Yes, I was just joking. We can definitely hear you, but that poor signal may be that you can wind up your speech.
Oh, okay. I'm just about finished. Should I turn off the camera, perhaps?
That's perfectly fine, Kim. Please go on. We can hear you.
Okay,
Yes,
good.
please carry on. Yes.
Good. Okay, because I'm getting a crackle on your side. Anyway, so the point that I was trying to make is that it's possible through a statute, this Hungarian statute told judges that anyone who entered Hungary through a safe state should be denied asylum, which meant that the judges literally had no discretion left in asylum cases. And it had the same basic effect as if the judge had been called on the telephone and told what to do in each case. So if you see, this is the problem. Can you hear?
Yes, yes, we can hear.
Oh, okay, sorry, because you're breaking up on my screen, so I'm assuming I'm breaking up on your screen. Okay, so anyway, so the thing I'm trying to see here, the point I'm trying to make, is that judges can be instructed through statute to do almost exactly the same thing that judges would be instructed to do if they were called on the phone and told what to do, right? So this is where they get to the next slide on positivism. So if the judge can be told directly what to do in the individual case by a legal norm that leaves no room for judgment, then the judge is completely dependent on the law, and the law is completely dependent on the will of a political authority. Well, so on one hand, isn't that supposed to be how it is in a democratic order? And on the other hand, isn't this a kind of threat to judicial independence? So next slide, and I'm almost done here. So what I want to think about is independence beyond the law. What would it mean for judges to be independent beyond the law? And this is where, as befits our workshop and befits our organization, let's bring the Constitution in. So one of the things a Constitution does is it gives the judge a set of principles to be dependent on instead of only the positive law. And if judges have principles to be dependent on, they are freed from being completely dependent on the law that is only politically defined. So constitutionalism allows judges to independently assess whether the rules themselves comply with constitutional principles. And constitutionalism also shores up the independence of the judiciary in the system of separation of powers. Yeah. So next slide to the one that actually Sergei might also like, on absolute vodka. And so the toolbox of the constitutionalist judge is to use the Constitution in all the ways it can be used to assess whether the laws are merely political direction or whether the laws really comply with the constitutional order. So obviously striking laws for failure to comply with the Constitution is something, but judges also have been very creative, including finding directive principles justiciable, for example, or at least indirectly so, finding constitutional amendments to be unconstitutional and so on. The Constitution gives a judge the toolbox to be quite independent of statute, and in many ways to stand outside the direction the political process gives the judge through statute to perhaps think of something else. So next slide. So the problem is that, of course, in a lot of countries now, the political rulers have figured this out. And so political officials are now engaged in a really unprecedented set of crackdowns on courts in a huge number of democratic societies where court packing and other kinds of sort of extraordinary efforts are now being made in order to limit how judges can decide cases. The next slide. So here's a set of some of the folks, some of the leaders that I think have been involved in this activity, who have in many ways restrained or restricted the operation of judges so that they can't just use the Constitution any old way to restrict political authority. Next slide. And so the question is, who defends the Constitution in those cases? This is a picture of actually a demonstration recently in Poland. As ordinary citizens went to the street holding these signs that say Constitution, and the T is you, the Ya is me, right? So this poster sort of conveys the thought that the Constitution is actually also something the people defend against political authority that has overstepped its boundaries. And so I want to suggest that ultimately the Constitution, and this is the last slide, is really the place where judicial independence is best protected, because it gives judges not only a way to be shored up institutionally, against the political branches, but it also gives them a place to stand to assess the constitutionality of the law itself. And the last slide just says, thank you.
Thank you very much, Kim, and thank you for being awake, because it is very odd hours, and keeping us it was a very lively presentation. You not only introduced us a number of theories and normative principles about independence, but also highlighted a number of case studies and what is happening globally. So that was very, very useful to set the scene. And as an exception, because we don't want you to keep awake for the whole of night, so just as an exception, I'm going to open the floor for any questions and comments now. And then we move on to the second speaker for this session. So there is a microphone here. So if you can raise your hand, the mic will come to you. Please introduce yourself and ask. Yeah, and you can, oh, it's very good. The mics are there as well on your desk. So please, may I see any hands? The first one is always difficult in a class, so who will break the ice? Okay, yes, Maris. Can you please ask the question? Yeah, thank you.
Great, thanks, Kim, for the presentation. It's just a couple of comments, really. In the UK, we've had an issue with the media and judicial independence, which is something we've had a big debate about in the UK. We had a national newspaper brand some judges enemies of the people on a front page of the Daily Mail. And so there's just to think about, if that's a threat to independence, what should the response be? Because the various trains of thought in the UK are to do nothing about it because it's a matter of freedom of expression, and that's just part of debate. Or perhaps the government minister should be able to defend the judges, or the judges themselves. It's appropriate for the judges themselves to defend themselves. So that's just a comment, observation to think about the role of the media in all of this as well.
Yes, Kim, would you like to respond to that?
Yeah, I'm afraid I couldn't quite hear it. I wonder if you could repeat the gist.
Well, the gist was just
the
thinking about the role of the
microphone
media. Thinking about the role of the media in judicial independence.
Yes.
And a culture, creating a culture of threatening judicial independence.
Yes. So how could media play a role in preserving, or I would also add, undermining judicial independence? What role do you see for the media in this process of judicial independence?
Yeah, this is a really good question. So I can say how not to do it, living in the U.S. Right now in the United States at the federal level, whenever a court makes a decision, the first thing the press reports is the political party of the president who appointed the judges, which makes the decisions look more political than they might otherwise be. So, one thing I think the media can try to do is to treat the decision as a freestanding decision and not as the result of a political process within the court. Now, there may be courts that are, in fact, very politically divided along partisan lines. I think the U.S. courts are like that right now. But it seems to me that the courts are also responsible for producing decisions that are supposed to transcend those particular kinds of political divides. So the more the media can understand sort of the internal culture of the courts and try to report on what particular decisions mean within the context of that judicial space, the better, which is to say that public education is really crucial. But if the journalists treat the courts like any other political branch, so will the public. And I think it's very important for the media not to do that.
Okay, thank you, Kim. Let us get more questions. I'll start with here. Yeah.
Thank you.
Yesterday we tried that. I don't know. We don't want to take that risk. Okay, we can try.
Okay.
Yeah, please.
Okay. Thank you very much for your conference. It was quite interesting. But I would like to ask you about optimizing the interpretation of the constitutional law to confront the authoritarian regime, because maybe in your point of view, are you charging a rule against the authoritarian regimes in the democracy crisis countries. And I ask you if the role of the judges in a democracy in crisis, like in Poland, on Ecuador, Venezuela, requires judges like Hercules, no support the charge or the wave of team, the justice that cannot to construct, cannot to build in the political arena, or in the other way, maybe the judge must to play a role in the negotiation, the conflict, looking for the consensus between the government and the opposition. But in any way, that is the role of the judges, or that is the task of the parties in the fight against the authoritarian regime. Thank you.
Yeah, I'm sorry that I'm only hearing like part of the microphones at the front of the room I can hear, but the ones that are in the room itself, I don't quite hear very well. So I couldn't, if I could ask Surya to summarize the question again, I'm very sorry, I just couldn't hear it.
If I got it right, so the question is about democracies in transition. So how do you manage this judicial independence in those situations where, and he mentioned Poland specifically, so
Yeah.
how do you navigate through judicial independence when the democracies are in transition and different political parties, they're trying to grapple with this issue, and they might have an agenda?
And the role of the judges in this case.
And what should judges do in that particular context?
Yeah.
Right? Okay.
Yeah. I mean, this is a really tough question, right? Because when the judiciary is really being attacked flat out by the government, especially in a parliamentary system where you don't have separate legislative and executive partisan compositions, I think this is very, very difficult. There are many judges. In fact, I was just recently at a conference of a number of judges from around the world, and this topic came up. And the judges themselves were very divided between those who said, well, look, when things are like that, you can't make it worse by making controversial decisions. You know, better to keep your head down and just hope it passes. And there were other judges who said, look, you have to stand up and be brave and do whatever, you can't let this affect how you would decide cases. Now, what I've seen in Eastern Europe, which is where I do most of my work, is that the courts that have actually tried to defend themselves the most have gotten the most external help and the most help from their own citizenries. So in Poland, I don't know how many of you have been following this, but within the EU, when a court gets a question involving EU law, they can make a reference to the Court of Justice of the European Union for an answer on EU law points. And recently, the Court of Justice had a decision about judicial independence in which they said every member state has to guarantee the independence of its own judiciary. So the Polish Supreme Court itself made now 3 references to the Court of Justice saying, essentially, they're firing us, these judges who were referring to you. Do we have to agree to be fired? In other words, they went out to the European Court to try to get backup for being defended against their own government. And a week ago Friday, the Court of Justice issued what's called an interim measures order to prevent judges from being fired. And right now, the Polish government seems to be going along with that, which is to say that the judges, by virtue of making a huge noise about this, called in external help. There was a point about 10 years ago, a little under 10 years ago, when the Romanian Constitutional Court was, the judges were being actually threatened with harm by people close to the government. And literally the judges sent out a notice to officials in the EU saying, help, we're being threatened, our lives are being threatened. And literally, within 24 hours, the European Commission responded and called the government to account, and the government backed down. So in these places where there are transnational bodies, the judges in these really extreme cases have been able to appeal out to the Council of Europe, the Venice Commission, the European Union institutions themselves, and they've gotten backup, actually, and that has helped them fight another day. In the meantime, the Constitutional Court of Hungary, which, tried to put up a brave fight as it was being packed, after it got packed, it went silent, and then nobody's helping it. you know. So I think what a lot of this shows is that if the judges are not defending themselves, it's hard for them to get anyone else to defend them. So I think they have to make visible what the threats are to their independence, because only then does the public rise up and do external forces rise up to try to help them. So, you know, it's hard, but I always counsel bravery in these circumstances.
Thanks, Kim. And now next question is Pablo.
Thank you very much. Wonderful presentation, Kim. But my concern is when you raise a very important issue, which is that under your perspective, judges must be above the law, even the Constitution, and their decision-making process should be based upon principles instead of statute. You know, it was a claim, as far as I understood, against positive analysis of the Constitution itself. So, to my knowledge here, we have a theoretical issue as regards to legitimacy in a model of separation of power. But far beyond of that, there is also some practical issues at stake. And I know that you are very familiar with what's going on in Venezuela, for instance, where as a practical matter, you know, the regime, the cronies of Maduro and the authoritarian regime are in the Supreme Court, and the resistance was in the parliament. So I think it's very difficult and can undermine this idea of the supremacy of the Constitution, even those principles, when we rely on judges, and those judges are cronies of the authoritarian regime. That's what's going on, at least in this very moment, in Venezuela. So here's what my question does. I would like you to react or to reflect something what's going on in Venezuela vis-a-vis this statement that you said that it is important that constitutional judges have their decisions based upon principles and not abide by the Constitution itself.
Kim, do you want me to reframe, very quickly summarize the question, or have you got it?
Oops, actually now I'm having trouble hearing everybody. I'm sorry, I think
I see, okay.
we have a bad
so
connection.
Can you hear me now?
Yeah, I couldn't, I'm sorry, I keep apologizing for this, but I couldn't hear the last question. I don't know
Okay, should I repeat?
if I can hear
should I provide?
And I don't see a picture anymore, so.
Okay. The question was that it seems Pablo understood your presentation. One of the points was that the judges should be above the law, they should be guided by the principles. But if we go by this logic, what will happen in those situations where the judges are the cronies of a political system, and he was referring to Venezuela in particular. So if judges of those kind are above the law, then what will be the outcome?
I think we've lost the connection.
I think not on our side, but okay. Now it is gone. So let us give it a go, otherwise
there you are. Okay.
but we can't see.
Hi.
Yes.
Okay.
Yes. So could
That
you
might work better,
could you
sorry.
get the question, or should I repeat quickly?
Oops.
Can you hear me?
Yeah, I can hear you just barely. I'm so sorry. As Surya knows, we had a 3-hour connection that was fine earlier in the day, but somehow
Yeah.
right now the connection
But
seems
can
to
you
be
hear
fairly
me now?
bad.
Should
I'm
we
sorry?
okay, let's try to do without the video.
Yeah, I'll turn off the video and see if we can just do the sound. All right. Yeah. So can you repeat again? Sorry.
Yes. So the question was that if one of your points was that the judges should be above the law, they should be guided by the principles, and then the question is that if the judges are to be above the law, what if the judges are cronies of certain political parties, and the reference was made to Venezuela? So how would you react to that situation in terms of the outcomes? Can you hear, Kim? Yeah. Probably we'll move on, I guess. Kim, are you with us? Can you hear us? Hello.
Okay, this might work better. I switched to a different machine.
Oh, all right. So, did you get the last question, or should I repeat myself?
You could repeat. I'm so sorry. I know this technological stuff is very challenging, so.
Yeah, not a problem. So the question was that one of your points was that the judges should be above the law. They should be guided by the principles. But if we apply this logic, what will happen in those situations where judges may not be really independent, but they are just the cronies of a particular political party? And a reference was made to Venezuela in particular. So what will be the outcome then?
Yeah, so this is the big question, of course. So all I've done is open up a space for more thinking about what exactly the judges are doing when they're doing constitutionalism as against law. And I think that, you know, the background to the question really comes from my sense of politics as a threat to the judiciary. And in contexts where you have a government that's repeatedly trying to rein in the judiciary, one of the ways that they do it, of course, is through passing statutes that the judges are called upon to enforce. And these are sometimes statutes that, you know, are asking the judges to dig their own grave, so to speak. And so these are the contexts where I really do think judges need to be quite brave. So just to give you another example from Poland, one of the things that the Polish government did as it was trying to close down the Constitutional Court was to pass a law that said the Constitutional Court could not review any law until it had been in effect for 3 months, starting with that law, right? And the idea was that the government was going to pass a whole bunch of laws that were going to essentially compromise the independence of the judiciary. So the Constitutional Court said, well, we can't have our jurisdiction restricted this way. And they went ahead and declared that law to be unconstitutional. So then the government refused to publish the decision. And then the other courts, the Supreme Court actually then made the announcement that it was going to follow even the unpublished decisions of the Constitutional Court, which is to say it wasn't just one court that resisted, but the other courts stood up to it. And this kind of really uniform response to this government pressure, including lawful government statutes that restricted the jurisdiction of the court, that's been the only thing so far that's been saving the Polish judiciary. So that's, and the government, you know, and now actually the Supreme Court as well, this just recently happened in Hungary too, the ordinary courts are starting to use their powers to declare laws unconstitutional, even though strictly speaking, only the Constitutional Court has that power. But once the Constitutional Court is packed, the other courts have been picking that up. So in other words, the judiciaries in these countries have been acting, you know, together, and they've been acting in a really strong manner, and that's been the only thing that's prevented them from being shut down altogether. So, you know, and so far, you know, at least in the EU, this is working a little bit because the EU then comes in and tries to save them. You know, if you're not in a place where there is this kind of, you know, transnational level above the national level to help, it's much more difficult.
Yes.
But still, I do think that when judges stand up for themselves, others notice, and others are likely to come to their defense.
Okay, thanks, Kim. We have at least 2 more questions, but I'm mindful of the 3, it seems, but I'm mindful of the time. So if colleagues allow me, can we close this here, and probably we will exchange the questions via email or something. We can continue the conversation, I hope.
That's fine.
So thank you so much, Kim.
That's fine.
On behalf of everyone here, we really appreciated you joining us via Skype, and it was a bit unfortunate that you could not join us in person, but I'm sure there will be other opportunities in future. Thank you so much.
I wasn't as active as I did, but so much. I wish I could see you all.
Bye-bye.
Bye.
Bye. All right, so, okay, so thank you very much. And then we move on to the second panelist for this session. And this is Professor Sergei Belov, who is a professor at St. Petersburg State University. So the floor is yours. And probably if you can, it's up to you. Yeah. So, and if you can finish in 15 minutes, then we have some time for questions. Thank you very much.
Okay, thank you. So, I will share with you some thoughts about the methodology of measuring judicial independence. We talk about judicial appointment in the light of judicial independence, but how we can evaluate the results, I think, is crucial to decide how we measure it. And the first point before I start I will address to is that the measuring judicial independence, to my view, appears more like a question of political science rather than the pure legal question, because the methodology of measuring judicial independence addresses the methods which are more about the surveys, the measuring in numbers, etc., etc. And on this point, this is very interesting and very important to decide what we base on. Do we base on facts and investigating the facts with methods which we have as scientists, or we base on expert opinions, on some evaluations and assessments, which make some grounds for conclusions as well, but to my view is sometimes disputable. So the first, in the legal or political science literature on judicial independence, you can find at least 4 dimensions of how the judicial independence could be. So the first is the institutional independence and decisional independence, meaning that the courts, the judiciary as the institution could be independent, or taking the decisions could be the matter for independence in a case or for judiciary in general. The second point is that judiciary could be independent from any external, in the first, the political branches of government, but the question about independence could be raised only also within the judiciary system, and this means that a judge could be dependent on the president of the judge or on upper judge, upper court, and this raises a question about what could be protected as judicial independence. The third point is that the judge could be independent making the decision, but another point which is addressed by many scholars is that if the judicial decisions are executed properly, that means the real power of the justice, of the judiciary, and this raises the question of independence as a real political force. And the last and probably the most remarkable and mostly often addressed question is the opposition, the balancing between de jure and de facto independence. And the institutional decisional independence is very close to that fourth dimension of independence, because institution is more close to formal de jure questions of independence, and de facto, of course, is more hard to measure. But at the first, I will address the measuring de jure independence, and the institutional one, making the assessments mostly in questions of appointment judges, of course, what we discuss here as the main topic of our roundtable, and the delimitations of competence of judiciary and other branches of government, financial guarantees to courts, the liability of judges. I can give you a few examples from my home country, and the appointment of judges could be a matter of assessment, but in my country there is a tradition that no advocates could be appointed as a judge. This is quite unusual for many jurisdictions, but in Russia it seems, it's supposed that someone who is outside the judiciary in the professional activity will come to judiciary with some presuppositions, with some social connections, which could be against the idea of independence. But how we could measure this threat to independence if we see these rules of nomination in a certain country? I would say that the most important methodological question is that we cannot do a certain evaluation in figures. We cannot make a score of independence when we see some questions of making pro and contra of judicial independence, and the approaches are very different. And the point of liability is very important also here, because on one hand, liability of judges is something as a threat to judiciary independence, but what we saw again in my country in 1990s, it was a lot of decisions, of arbitrary decisions by the courts. So their discretion goes that far as it was a threat to the law, to the rule of law, and to the judiciary authority as such. So the approach to institutional measuring is quite obvious in positions, but not so obvious in measuring that independence. Many writings, many articles and books now are now concern the de facto independence of courts, and I try to investigate how the authors of these writings address the methodological question. And it was quite clear that most of authors who write on this, on the measuring de facto independence of courts, they suppose that first sign of judicial independence is that the court decide against political branches of government. So if the court supports a political decision, that means that they are dependent. I think that's not so clear conclusion, and it is quite weak as a methodological approach in general. Another point is that to judge about the independence of justice, we could follow the career of a certain judge who decided a case in favor or against the government. Was he or she successful in career of the judge, and we could decide if the decision was favored or not by the government and by those who take the decisions of the career. But this is quite measurable, but very doubtful numbers and measures of judicial independence, to my view. And what I saw as researchers of worldwide judicial independence reports, I saw that there are some correlations established between the judicial independence and some other political issues like political competitions, the democracy developments, the press freedom, etc., etc. But I think it is more about the consequences of judicial independence, but not measuring independence itself. But when I addressed how these researches bases on the facts, there are two general approaches which I could find in all these writings. So first is expert assessments. And this is the most favorable and the most used way of assessment of judicial independence. But sometimes it is quite clearly, explicitly shown, sometimes not. But most of researches are based on I would say secondary expert opinions, meaning that there is expert pool of experts who did their assessment, and then conclusions about the judicial independence in a certain country, and then based on this expert assessment, other conclusions are made. But in many writings, they address to the expert assessment by the US Department of the State and the reports of Amnesty International, Freedom House, and what I saw, there is no methodology, clear and certain methodology of making these expert opinions gathering. I mean that there is no information who were these experts, how they did their conclusions, what was the methodology of interviews, etc., etc. And the other approach, which is also very important and very spread in the legal literature, legal political science literature, is using the numbers, the statistics. And the statistics mostly about the cases decided, who were the parties to the cases, and what was the outcome of the case. And if it was, again, in favor of the government, then it is supposed to be not so independent. And I think this is the very important point to show where we base on our conclusions about judicial independence. So, going to the general conclusions, I will point that actually we have quite two main points about the judicial independence, what we should support the independent judges from, and the Kim's point on the independence from the political branches, I would add with some economic consequences which sometimes are taken into consideration by courts when making a decision, some public perception of the public opinion about the judges' decisions, and the political ideas, the internal policy of the state, which is supported or not supported by the judge, could be a question of independence, but I would not conclude that this could be a clear point for measuring judicial independence quite clearly, what could be the independence from those unlegal arguments and on legal consequences of a decision. And the most important which I see is that the measuring of judicial independence is mostly based not on facts, but in many cases at least, they are based on the opinions and assessments, which could be, of course, a matter for debates, but not I would say a scientific methodology for making a conclusion. And the last point is that all the researches which I saw on judicial independence just put aside a question which is very important for us as legal scholars, that the judge could have legal arguments as the guiding arguments for a case. And that is taken out of any assessments for methodology of independence, because only political context, political consequences is taken into consideration to decide if the judge was independent or not. But when we take this point, we presume that there is no legal grounds which could be the guiding point for judges, but we think that the discretion of the judge is too wide to decide almost arbitrarily all the cases which are in front of the court. So thank you for your attention.
Thank you very much, Sergey. And let us now open the floor for questions and comments. And I think it might be better if I collect 3 or 4 questions together, and then probably you can respond.
Yes, surely.
So, Professor Molly-Hongres.
Yeah, thank you, Professor Sergey. Yeah, your analysis, methodology analysis is very interesting. I just feel very interested in your consequence. You think just the outcome of the cases of the judges carry. Maybe this two field, and then we can find the independence. So what's my question just about the outcome of the cases? How do you find clarify the clear outcome? Because maybe there are some the real outcome and also the potential outcome. How can you identify the judge's liability, legal liability? Maybe I'm not quite sure whether you agree. Maybe just ask the judge, just take charge of the legal liability to predict or evaluate any potential political influence caused by the judgment made by himself. So whether, shall we? Yeah, thank you.
Okay, so Helen.
Thank you very much. This was really interesting. I noticed in your presentation that you referred, as I understood you, purely to quantitative. Computerized studies. But don't you see some more possibility maybe in measuring independence if you combine the quantitative studies with qualitative studies? And I also noticed in your presentation that you were, I'll try again. So when discussing quantitative studies, you were, yes, it doesn't like me, I'm sorry. Is it okay if I turn it off? I'll just speak up really loud.
Yes.
Okay. So furthermore, in your presentation, I noticed that it seemed to me that you focused on, especially on following the, is it you? Okay. On following the political opinions in your quantitative studies. That was, as I understood, your focus. But what about focusing more on sort of specific political areas and looking at how different judges act within specific political fields through their career in their judgments? I believe that's what they do in the US, where they have a lot of research in this field. So those are my 2 questions. Thank you.
All right, so I'm trying to give floor to those who did not ask questions in the first round. So trying to be more inclusive. I see more hands, but I will give floor to
Yes. Thank you, Sergey, for your interesting presentation. I would like to say that according to the jurisprudence of the European Court of Human Rights, there are 2 ingredients that should be taken into account. One is the guarantee against outside pressures, not to be subject to instructions, not to be removable. I think that's the most important, in fact, not to receive instruction and not to be removable. But also there is a very interesting jurisprudence, related with the appearance of independence. Justice must not only be done, it must be seen to be done. And I think that every day this is most important, those 2 ingredients, appearance of independence and guarantees against outside pressures. Besides, I think that we have to consider that nowadays in Europe, in the European Convention and in most of the constitutions, independence is a fundamental right. It's not only a principle which inspires the organization of the judiciary, it's a right of every citizen. So we have to measure how ordinary citizens are capable to challenge judiciary decisions by themselves. I think that has changed the perception on the idea of judiciary independence. Of course, I don't know how to measure that. That's the question. But I think we have to fix a little more the parameter.
Thank you, and may I now invite Sergey to respond to these questions, and then we take a second round. So yeah, thank you, please. And if you can be brief, then we can collect some more questions.
Thank you. So about your question on the political influence, I think that the judge could be asked, if I got right your question, could sometimes make the position of the decision mostly based on the legal arguments only, and everything which was decided could be at least represented as having no political dimensions at all. And at least I would say, if in Russia you would ask a judge if there were any political debates or political arguments involved, there will be answer no, definitely, in all cases. And that's why it's quite hard to decide what is the real independence from a political view. Although, of course, I'm the most familiar with the practice of the Constitutional Court, and I sometimes ask the judges of the Constitutional Court about some sensitive questions which they hear, and I do see that most of them really believe that the cases they decide mostly basing on legal principles and values rather than taking in consideration any political dimension of the case. So about your question on quantitative and qualitative, I see that the expert opinions assessments is a kind of qualitative attempt to do this, to make it more more statistical on the second round of the research, but on the first it is just making evaluation if the judges are independent, if they are liable to the political branches, etc., etc. But when all the researchers goes to the conclusion, they need to mark a certain judicial system in a country, that this judiciary is independent for 0.8 out of 1. And this is the outcome of most researches which I saw. Sometimes it is not like that, but just description of what are the nuances and some questions how the judiciary is independent. But most which I saw was not about this methodology, at least. And the idea how we could involve these political questions within this evaluation, I would say, is a very tough question and not decided yet. And the last question asked about the elements of the judicial independence. Of course, I quite agree with you that there are some elements, but my point is that it is very hard to decide what is fulfilled as the parts of this practice, and if these principles are realized in fact in a certain judiciary. Of course, no judge will say that she or he got an instruction from outside. and got the instruction about a certain case or about the general approach to decide cases, but still this is not a case to decide what is the independence of the judiciary.
Okay, let's take two more questions. Professor Han is one. Okay, I'll give you the floor. Will be two or three. If you can be very brief.
Yeah. Okay, this is a great honor. So, my question is that I like the focus on the U.S. Supreme Court Kavanaugh issues. So many people focus on the Kavanaugh former nominate, but now is successfully into the Supreme Court. That is the American issue. But we need to consider about why in this case all the politicians yes, Democrats no. There's quite different ideas. So from Russian, the scholars, how do you comment this case, these issues? How do they maintain the political and the rule of law? If in the Russian happened some similar case, what situation? Thank you.
Okay, very good.
Thank you.
As we are researchers, my question is very concrete. Which is the role of the legal education in the future of the justice of judges? Do you think that it could be measured, the impact of the education in the future or not independence of judges and the institution? Thank you.
I just had a quick question about the role of the European Court of Human Rights. If we think about a measure, an external measure of judicial independence, you often see very gross violations of human rights progressing through the national courts, which are not appreciated as gross violations of human rights until they get to the European Court. So it can sometimes be a very good indication that perhaps there's something wrong in the national system. So I just wonder if that's a way of measuring judicial independence with an external arbiter.
The final question, Pablo.
Thank you very much. It is somehow connected when I raised before. My question is that, to my knowledge, there is a connection between independence and fairness. I think, as a matter of a constitutional design, this internal and external view of independence is based upon the idea that all judicial courts' decision-making are based upon legal thinking and based upon, the law and the Constitution. So avoiding the tit for tat, the idea of can be a compensation, judges making a decision in favor of government or whatsoever. So here is where my question comes again. In order to measure independence, I would like to know whether you think that it is reliable to think that judges must make their decision-making based upon principles. Because it's easier to make this kind of measurements to see if the rationale is connected with the dicta, if it is based upon the positive law. Whereas in the other way, it's rather difficult.
Thank you.
Thank you. Yes,
thank you.
You can respond.
Okay. Yeah. So first question about the U.S. Supreme Court and nomination of Kanagawa. Well, looking from Russia, it seems very political procedure of nomination and appointment of the judges. And what we try to do and what we see in nomination and appointment of judges in Russia, there are no political debates on this. And even in the Constitution, we have guarantees that the upper chamber of the parliament, which is not politically elected, it is appointed by the legislative and executive of Russian regions, but not with the political parties' campaign. And this is a guarantee that the appointment of judges will be unpoliticized. So it will be not about the political parties' opinions about a judge and about political views of a judge. Of course, it's not a guarantee that there will be no taking in consideration the political views of a nominee, but as a general, it is not a part of the procedure of nomination and appointment. And of course, what I see in the US is the courts, the judiciary is somehow a part of political system in general. And it was quite remarkable article which I once saw in Harvard Law Review, that in the US system there is a balance between parties, both in the executive, legislative, and judiciary. And you can see this is as the outcome of any cases which heard by the US Supreme Court. So this is one more case in support of this approach. The question about the role of legal education, I would say, is very important point for any judges anywhere. And of course, the legal way of thinking could be quite a very important position to provide the independence of judges, maybe not against the external, but against internal dependence within the judiciary. Your question about the European Court of Human Rights. Well, what I see in jurisprudence of the European Court of Human Rights sometimes shows the critical problems of judicial systems in member states of the Convention, of the European Convention, but I would not say that the court quite often address the questions of independence. The applicants to the European Court sometimes appeal to reasonable time of hearing a case. And this is the question which has nothing to do with independence, but there are a huge number of cases in the European Court of Human Rights on this very point. And they are about both Italy, Turkey, and Russia, which are quite different with the point of judicial independence.
No, I had in mind Article 13 violations, more specifically. So, but we can talk about it later.
Yeah, probably, yes.
Yeah, okay. And Pablo's question on fairness, and I see that, of course, in many, especially in transition political systems, judiciary, and the systems of post-Soviet, post-communist regions, we have a lot of this heritage of the Soviet approach to the law as a letter of law. And of course, this gives a lot of threat to independence, because when we base a decision only on a letter of law, that means that it could be decided in any direction. And of course, I fully agree with the approach that, of course, the court should address legal principles in making any decision, and this would be more grounding for any legal cases heard by a court. And this is a very important point for development of judiciary, and this could make the judiciary independent, dependent on legal, as Kim represented on laws and the Constitution, and independent from the political issues.
Thank you very much, Sergey, and may I invite all of you to have a round of applause for both Kim, who is not here, and Sergey.